State of Ohio versus Megan Stowers, case number 25CR1491. The defendant is present with counsel Bill Watson. A one-count information was filed in this case on December 30th, 2025. The one count is aggravated possession of drugs, a felony of the 5th degree, in violation of Revised Code 2925-11A with a forfeiture specification. It is the state's understanding that today the defendant would like to waive her right to have the Lake County Grand Jury indict this case and will be pleading guilty by way of information to this one count. The state will be recommending community control sanctions, and we are also here on the defendant's motion for intervention in lieu of conviction.
Thank you. Mr. Watson, would you like to be heard on your motion?
Thank you, Your Honor. May it please the court. I'll just briefly say for the record, Your Honor, that motion initially was filed in good faith. I was unaware of out-of-state charges and apparently current pending warrants. So I've already explained to my client that based upon that, she's not going to qualify for the intervention program, Your Honor.
Well, the court is going to deny the request for intervention in lieu of conviction based on the criminal history here. There's outstanding warrants from the state of Georgia. She's been on a diversion program before in the past. She's got prior felony conviction. So I'm going to deny that request. But my understanding is your client still wants to enter a plea of guilty to the charge. Is that correct?
Thank you, Your Honor. May it please the court. Yes, that is correct. I have spoken to my client. She would like to proceed by way of information. I've discussed this matter with the prosecutor. I believe full discovery has been provided. I've also discussed this matter with my client. First, she is prepared to enter a change of plea by way of information. She understands that by doing so, she'll be waiving her right to have this case presented to the Lake County Grand Jury. Furthermore, by entering a change of plea, she understands that she'll be waiving certain constitutional rights, and no threats or promises have been made in order for her to do so, Your Honor.
Thank you. Is it Stowers or
Stowers.
Stowers. Were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your plans are here at this time?
Yes.
They indicated to the court they believe it's your intention to waive your right to have this case presented to a grand jury, and I'll explain in more detail here in a second what that actually means, and to plead guilty to the charge and the information, which I'll also review with you to make sure you understand that. We would then proceed to sentencing.
Yes.
Is that what you want to do?
Yes.
Well, before I can accept your guilty plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I have to ask you a series of questions. If at any point when I'm asking you any of these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
All right. Let's get started then. How old are you, ma'am?
I'm 39. I'm 40. I'm 40 now. I'm sorry.
Second person that had trouble with their age today.
I'm sorry. I just turned 40.
I think you both were 40 too. You able to read and write the English language?
Yes.
Any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here today, have you had any drugs or alcohol of any kind?
No.
What about in the last 48 hours?
Nope.
Not even prescribed medication? Nothing?
Oh, I take my medication.
Okay, what is that?
I take Invega. I take Invega, Tenex.
What is it?
Tenex.
How do you spell that? Do you know?
Tenex.
Oh, all right.
And Topamax.
Anything else?
No.
Now, I thought you were on some type of medically assisted treatment.
What do you mean?
Don't you get a shot?
Oh yeah, I get Brixadi. I get the Brixadi shot.
Okay, but that's what, is that a monthly injection?
Yeah, monthly.
Oh, so that's when I said within 48 hours, that was...
Oh yeah, I'm
but,
sorry. I get
but
the
it's a monthly injection.
It's a monthly injection. I get that on the 4th.
What is it called?
Brixadi.
I never heard of that one. Okay. Okay, how long have you been doing that?
3 months.
Okay. All right, the other 3 medications, do any of those affect your ability to understand or appreciate where you are, what's going on around you, or anything like
No.
that? Okay. Now, did you receive a copy of the information that was filed in this case? That's the document that sets forth the specific charge you're accused of committing?
Yes.
And you had a chance at some point to look that over?
Yes.
Now, in that information, you are charged with 1 count, and what's alleged here and what you'll be admitting to is on or about April 16th, 2025 in Willowick Lake County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance containing methamphetamine, which is a Schedule II controlled substance, and the amount involved did not equal or exceed the bulk amount, which makes the offense aggravated possession of drugs, a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1?
Yes.
Any questions about it?
No.
There's also what we call a forfeiture specification that's a part of this charge. It alleges that you, during the commission of the offense, possessed or had an interest in property considered to be contraband or an instrumentality. Contraband's property that's illegal just by the nature of the property, like drugs. Whereas an instrumentality, some type of property that may not be illegal in and of itself, but it's being used in an illegal manner to facilitate a crime, and you can't use or possess it for that purpose. And here it's alleged there's the methamphetamine along with some syringes and some pipes. The whole point of this is that you forfeit any interest, ownership that you have in this property. You understand that?
Yes.
Any questions about it?
No.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have the right to have this case presented to a grand jury. So that charge that I just read to you is called an information. And an information is a criminal charge brought by the prosecutor's office without this case having previously been reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest a person probably committed a criminal offense. Now, everyone here in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. You have that right as well. But you can't give up that right if you desire. Go forward in the charge brought by the prosecutor, and your attorney has indicated he believes that's what you want to do. Is that correct?
Yes.
You have a question for me about that?
No.
Okay. Well, before I can go any further, I need to have you acknowledge that here in open court in writing. And I have in my possession here a document called a waiver of indictment, which sets forth what I just explained to you about the grand jury process. Now you want to give up that right. Before I can go any further, I need to be assured you understand this document and that you sign it here in court. Now, my understanding is you did have a chance to go over this with your lawyer before I came out here. Is that correct?
Yes.
Mr. Watson, is that accurate? Did you review this with your client, go over with her, answer her questions?
Yes, Your Honor, I did review the waiver of indictment form. I read it to her, explained it to her. She read along with me, indicated she understood it, and she signed it, and I signed it in the presence of the prosecutor, Your Honor.
Is that correct, Ms. Stowers?
Yes.
So you went through the document, you understand it?
Yes.
Any questions for me about it?
No.
It does appear you signed it like your lawyer said. Is that accurate?
Yes, sir.
Ms. Gold, you witnessed that also?
Yes, Your Honor.
All right, I'll make that document part of the record. At this point, I'm going to review with you all the other rights you have that you're giving up by pleading guilty. And you first of all have a right to a trial. Now, a trial could be to me as a judge, or I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be a unanimous decision. Unanimous means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes.
You understand by pleading guilty you're giving up your right to have a trial?
Yes.
Now, if we had a trial, prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation to prove you guilty before you could ever be found guilty. You're presumed innocent of the charge, and the presumption of innocence will stick with you and remain with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when I speak of this burden of proof, since this is a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. That's the highest burden there is in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence that the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of this charge beyond any reasonable doubt before you could ever be found guilty of the charge. You understand that?
Yes, sir.
You understand by pleading guilty, you're giving up your right to have the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
Now, in order to try to do that, if we did have a trial, the prosecutor would bring witnesses into the courtroom to testify for the state. They'd be answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. That's called cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir.
Now, you also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you want to. Do you understand that?
Yes, sir.
And you further can request the court issue an order. We call that order a subpoena. And what a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. You understand that?
Yes.
You understand by pleading guilty, you're giving up that right?
Yes, sir.
Now, you also have the right at a trial. You can choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and answer questions. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
Further understand that if we went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to another court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could raise or brought to my attention up to this time. You understand that?
Yes.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have, all the rights you give up by pleading guilty. Any questions? Do
No, sir.
you understand them all?
Yes, sir.
You still want to plead guilty?
Yes, sir.
You understand a guilty plea is a complete admission of guilt, so you're going to be admitting to the facts being alleged here. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you
Yes,
understand
sir.
that? Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you'll subsequently, on a future, today, because we already did all the paperwork, you'll subsequently be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, you're pleading guilty to one felony of the 5th degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes, sir.
Now, are you currently on probation or parole to any of the courts or agencies
I'm on probation.
with Cuyahoga County?
Yes, sir. On lieu of conviction.
Sorry?
In lieu of conviction.
Right. And that was an offense that occurred right around the same time as this, right? Actually, it was before?
Yeah.
Okay. So when this happened, were you on probation anywhere?
No.
Okay. I know you got some other charges pending out of state. Anything pending in state?
No.
If prison were ever imposed in this case, upon your release from prison, you could be put on what is called post-release control. We sometimes call that parole. It's a period of supervision you would be on after you serve the prison sentence. In this particular case, it could be up to 2 years. Do you understand that?
Yes.
And if you were on post-release control and you ever violated it, conditions of your supervision, we would have a hearing. The parole board would have a hearing to see if you're what's called if you violated your parole. If they found that you did, they could return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, sir.
Now, aside from the possible prison sentence I just mentioned, there's other sanctions that could be ordered. You could be fined, in this case, up to $2,500. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment if any that were applicable. Do you understand that?
Yes, sir.
You can also, I would also have the ability to suspend your driver's license for up to 5 years. It's not mandatory, but I could do that. Do you understand that?
Yes, sir.
Do you have a driver's license?
Am I suspended?
You're on your suspension right now?
Yeah. I can get it reinstated.
We'll talk about that in a few moments then.
Yeah.
Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible because prison's not mandatory with this charge. You are eligible for probation, what's called community control sanctions. Do you understand that?
Yes.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that if that's what you're asking for.
Yes.
I'll look at all the information that's provided. Then I make the decision I thought was the right thing to do. Do you understand that?
Yes, sir.
Now, if you were put on probation or community control sanctions, it could be up to 5 years. And as judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of those conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes, sir.
Further, if you're on probation, you ever violate any of the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't initially 5 years. I could order more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I sent you to prison at that point, again, it could be 6 to 12 months in prison, which could be consecutive to anything else that you're serving, if there is anything else, or that you're being sentenced to. Do you understand that?
Just say yes.
Yes.
You need a moment, or are you all right?
I'm fine.
Just take a deep breath. It'll be okay.
Lastly, when we do proceed to sentencing, I'll take a second. All right?
Yeah.
When we do proceed to sentencing, you're going to have the right at that time to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. He's allowed to recommend the sentence to the court. The prosecutor could also recommend the sentence to the court. Do you understand that?
Yes.
Do you understand that whatever anyone says at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I don't have to go along and follow that if I didn't think that was the right thing to do. Do you understand that?
Yes.
Are there any questions about the possible penalties you face by pleading guilty here?
No.
Understand all the potential consequences?
No.
You don't?
Yes, yes,
Let me ask the question again. Do you understand all the possible consequences that could happen by pleading guilty?
yes,
Any questions for me?
no,
Do you still want to plead guilty?
yes,
Have you had enough time to talk about this case with your lawyer and have him go over everything with you and answer your questions?
yes,
Are you satisfied with the advice and counsel of your lawyer?
yes,
Has he or anyone else made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty?
no,
Have you been threatened or coerced in any way to plead guilty?
no,
Are you entering the guilty plea freely and voluntarily?
yes,
Any questions for me at this time regarding anything we've just talked about?
no,
Do you need any more time to talk to your lawyer before we go forward with the actual plea of guilty?
no,
All right, then what's going to happen at this point is the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to her because I'll have some questions for you about that, all right? Okay?
yes,
All right. Ms. Gold?
Thank you, Your Honor. The facts would show that on or about April 16th, 2025, officers' attention was called to a vehicle in the parking lot of the library in Willowick, Lake County, Ohio. The interaction resulted in a search of the vehicle where officers located suspected controlled substances determined to belong to the defendant. They were taken to the Lake County Crime Lab for testing and tested positive for less than bulk amount of methamphetamine, a Schedule II controlled substance.
So, Ms. Stowers, were you able to hear what the prosecutor had to say regarding what she believes the facts would show if we had a trial?
yes,
What, if anything, do you have to say about those facts as she just explained them? Are they true? Did you do what she said?
yes,
Very well, then, regarding count one, charging with aggravated possession of drugs, a felony of the 5th degree, drugs being methamphetamine, along with the forfeiture specification, what is your plea to that?
guilty,
All right, I have in my possession here a 4-page document called a written plea of guilty and judgment entry, which sets forth everything we just talked about. Before I can accept your plea, I need to make sure you understand this document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
yes,
Mr. Watson, is that accurate? Did you review this with your client, go over with her, answer questions?
I did review the written plea of guilty form with Ms. Stowers. I read it to her. She read along with me. She indicated she understood it, and then she signed it, and I signed it in the presence of the prosecutor, Your Honor.
Is that correct, Ms. Stowers?
yes, sir,
So you went over the document,
yes,
and you
sir,
understand what it says?
yes,
You have any questions for me about what it says?
no, sir,
It also appears, as your lawyer indicated, that you signed the document. Did you sign it?
yes, sir,
Ms. Gold, you witnessed that as well?
Yes, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court. Hang on one second. She's in open court with her lawyer, advised of all her constitutional rights, and made a knowing, intelligent, voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count one, aggravated possession of drugs, a felony of the 5th degree, violation of 29-25-11 of the revised code with the forfeiture specification. The court has already ordered and had prepared a pre-sentence report and investigation. There's a drug and alcohol evaluation as well. Mr. Watson, is there any reason not to proceed with sentencing at this time?
No, Your Honor.
Anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court. I'll be brief. Again, the initial intervention motion was filed, Your Honor, in good faith. I know upon learning some stuff this morning that my client does have a bit more of a record than I initially thought, and most of it, if not all of it, is drug-related, Your Honor. I can tell you when I first met Ms. Stowers, and this was fall of last year, she has told me that she is determined to beat her addiction. She has a 16-year-old daughter currently going to Lakewood High School. My client resides in Lakewood. She did have the pending case as well in Cuyahoga County, and I believe in part based upon that, she went into treatment. And, I'm happy to report, I think there's some positives here, Your Honor. She's successfully completed her treatment. She's also been going to counseling, mental health help. So she's getting that addressed. She's obviously still on some medication to deal with addiction. And she has a clean test most recently. So I think she's headed in the right direction. What she's been doing with her time during all this, obviously she was going into treatment, but now that that's wrapping up, she's in a jobs program through Cuyahoga County. And so she's getting training. Her plan is to get back into the workforce. I'm hoping the court will consider a community control sanction. I know she has warrants out of another state. I just informed her about that. I don't know if she was fully aware, and I didn't have a chance to talk to her fully, but she told me she's going to address that as soon as possible. I know that's normally a huge red flag, but I'm hoping the court will take into account everything she's done so far over the past several months. She's heading in the right direction. If the court considers her for community control with whatever restrictions the court deems necessary, I think Ms. Stowers is going to show this court that she can be sober and be a productive member of society. Thank you, Your Honor.
Thank you. Ms. Stowers, you have the right to address the court before your sentence, as I explained just a few moments ago. Say anything you'd like. Is there anything you want to say at this time?
I am so sorry for my record. I literally, I have been trying my best to do everything that I can to prove myself. I've been in everything. I've been doing the workforce. I've been staying clean. I've been doing everything I can to prove myself. So please give me the chance to just keep trying to prove myself. Tomorrow I have testing. I've been doing everything I can.
What's the testing for?
The workforce program that I've been in.
So tell me about that.
It's for training to help people get back into working. It's through SNAP benefits. It helps people get jobs.
So what's the testing entail?
I'm sorry.
Take your time.
I'm sorry. It's through the job.
What kind of testing are you? I mean,
It's
a written
test?
test?
It's a written test. It's a written test. It's on computer.
What are they testing? Like what
It's the CRS training is retail. It's for I'm sorry.
If you want to sit down, you can sit down. If it's
It's the CRS training. It's the customer service retail training.
Are you also doing phlebotomy training?
Yeah, they actually had me in the phlebotomy training also. They wanted me to start in that also, and I was questioning that because of the blood and the needles. But they have multiple things that I can actually go in, and right now I'm just finishing up the CRS training. And like I said, I finish that tomorrow, and I have to finish up my testing, all the rest of the tests.
Do they help you find work?
Yes, they don't exactly do job placement, but they help with job training and getting a job.
Okay. So what is your a typical day for you? What's that like?
I do virtual training. I do the virtual training, and I go into the classes, and I don't just sit around. I go in and I do my classes, and I do virtual training, and I do things like that. And then I help my mother. My mother has breast cancer. She finds out tomorrow for sure she has breast cancer. I help her around the house. My daughter, we've been having a time with her, but we're trying to get that worked out. But I don't just sit around.
Okay. So what's the status of your license?
It was under suspension. I can get it reinstated, but I haven't. I don't drive.
Why don't you drive?
I got into a bad car accident, and I almost died, and I have bad PTSD from it.
So how do you get around?
I get rides from my stepfather and my daughter and friends, but I don't have any friends anymore, so it's really just my stepdad and my daughter.
And I certainly can appreciate the nervousness of driving if you've been in a major accident, but it seems like life would be easier if you're able to drive and get yourself around, wouldn't it?
Yeah.
You don't think you're able to do that?
Yeah, I am.
What do you have to do to get the license back?
I got to pay a $200 fine, and then I got to get the reinstatement fee and then do the driving test.
What? There's a fine and a fee.
Yeah, I got to pay a fine and
What's the fee, do you know?
I don't know.
Not sure. Okay. Is there anything else you'd like to say?
I do apologize for what happened, but I don't hang out with anyone anymore. I continue to do right, and I'm continuing to do right, and I'm continuing to stay clean, and I just want to do right now.
Tell me about the medication that you're taking. What is that?
Topomax and Vega.
No, not that. I'm sorry, the medically assisted treatment, the shot you get, the monthly
The shot, I get the monthly shot. I get the monthly shot just so I can stay clean, and in case I do.
Does it seem to be helping you?
Yes. Yes.
What does it do? Does it prevent cravings, or
It prevents cravings.
is it working for you?
Yes.
What was your drug of choice?
It was meth.
And that's what it helps you with?
Yes.
Is there anything else you'd like to say?
Thank you for giving me the time to speak.
Mr. Watson, anything else?
Nothing further, Your Honor.
Ms. Gould for the state.
Thank you, Your Honor. The state is asking for community control sanctions.
Well, I've reviewed the pre-sentence report and investigation, drug and alcohol evaluation that was completed. I've considered the facts and circumstances of the offense involved, the nature of that offense. I've considered everything that's been said here today by Ms. Stowers herself, her lawyer, prosecutor, the recommendations. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, nothing stands out factually indicating it's more or less serious. For recidivism factors, the court finds the defendant committed this offense while on bond to other courts. She has an extensive criminal history. She has in the past failed to comply with previously imposed sanctions ordered by courts. Certainly there's a drug abuse problem that relates to the offense, though I can't say she denies it or refuses treatment. She's done the opposite in that regard, which is a factor that to me actually indicate recidivism is less likely. Considering all the foregoing, the court finds at this time that prison is not consistent with the purposes and principles of sentencing, and the defendant is amenable to available community control sanctions. So I'm going to place you on community control sanctions for a period of 2 years, and I'll give you the opportunity to continue with what you've started here.
Thank you.
I want you to, I don't know if there are any aftercare recommendations from the PHP and the IOP, but if there are, you need to comply with whatever aftercare recommendations.
I was actually thinking about doing the NA. They don't do aftercare. They just recommend you to do the NA programs and things
all right, well,
like
that's
that.
going to be a condition anyway. So, all right. So if there's no, so then I want you to attend 3 AA or NA meetings a week and have a sponsor.
Okay.
You're not to use any drugs or alcohol, and that includes no marijuana.
I know.
So I know you didn't know that initially. You were told that, and then you tested clean for that. So that's good. So keep that going. But you're not allowed to use any drugs.
All right.
You have to submit random urine screens when requested. They have to be negative. If it's a positive screen, that would be a violation.
Yes, sir.
You can't screw around or tamper with your urine samples. Can't bring in fake urine or someone else's urine or anything like
I
that.
don't plan on that.
Well, a lot of people do that.
I
and
wouldn't.
that's worse to me than testing positive, to be honest with you. I want you to continue with this jobs training, and ultimately, and hopefully soon, because it seems like you're near the end of that, you obtain and maintain full-time employment.
Okay.
Or education. If you want to go and get some type of training or something to work towards something else, you can do that too. But a full-time basis, I want yourself working, going to some type of school or training, or some combination of the two to keep yourself busy full-time.
Okay. Did you want proof of me being in there?
Being in what?
Did you want proof, some type of proof of me being in there?
Like your job?
No, the workforce.
Well, I'm assuming that's coming to an end, right? And you're going to be working soon.
Yeah.
Yeah. With your probation officer,
Okay.
you need to provide. I mean, that's towards obtaining the employment, but you can't be on this program for 2 years. You need to ultimately, obviously, get a job and start working. And it sounds again like you should be close to that if you're at the end of this. So you need to keep them up to date, your probation officer, what's going on. But ultimately, you need to obtain full-time employment.
Yes, sir.
Okay. I want you to continue with the medically assisted treatment, following all recommendations in that regard for that type of for the treatment program there. I want you to continue with your counseling through Signature Health, the mental health counseling, as well as any psychiatric counseling, and take whatever, if any, medications are prescribed, and take them as prescribed.
Yes, sir.
You're only to have one doctor and one dentist that can prescribe you medication. If you have a specialist, that's fine too.
Yeah.
But probation needs to know who the doctors are that prescribe you medication. You can only get them from those doctors.
Okay.
And you can only fill them at one pharmacy, so make sure they know where that is as well.
Okay.
And you need to sign whatever releases they need to have you sign so they can contact and talk to whoever they need to talk to.
Okay.
You pay your court costs and supervision fees. I'm going to order that you have no contact with the co-defendant here, Michael Cooper Habit.
I don't even.
Well, and that'll be an easy one for you then.
Yeah.
I think that covers everything. Oh, I'm going to order the forfeiture of the contraband and instrumentalities. Derek, is there anything else I should be thinking about here?
No, thank you.
So, Ms. Stowers, you understand all the conditions of your community control sanctions?
Yes, sir.
Any questions for me?
No, sir.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another crime while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison.
No,
And if I did that, it would be 12 months in prison, which would be consecutive to any other sentence you could be serving for some other case. So, whether you're being sentenced to at that time, understand that?
Yes.
All right. Any questions for me?
No, sir.
All
Thank
right.
you.
Mr. Watson, anything else for the record?
Nothing further, Your Honor.
Ms. Gold.
Nothing from the
All
state,
right.
Your
Thank
Honor.
you all.